interesting part of our country's Constitution, and it's a really, I always find it to be a little bit fascinating here. The Supreme Court is a little different. It's not the group you see on TV. It's not the group you see interviewed generally. Obviously, you guys watched in a previous assignment a former Supreme Court justice talking to Jon Stewart, but you're not going to see these people on a daily basis. And for most of us, you know, we don't even know their names. Many people don't even know that this court exists, as Sandra Day O'Connor mentioned in her, again, that previous assignment. What's fascinating about them is that it's not your typical courtroom. It's not your typical, you know, what we might envision from the news and the dramas of movies and things that we see. In fact, even in film, there's only been a couple instances where the Supreme Court is even shown. And so it's just a really unique part of our government. They don't televise. So let's get started. And again, we'll mention some questions for you to go with. All right. First and foremost is that the Supreme Court is the only court that is actually created by the Constitution. It's defined in there. It's Article 3 of the adjudicate that. Now there's 9 justices. There's a Chief Justice and 8 Associate Justices. It is a hierarchy. However, the Chief Justice really only has that the title is Chief. When Justice goes first, and then the next 8 state their case. But in general, it's not. It's an equivalent thing. So there's no connection point between being chief and having any extra power. The Supreme Court is the final authority on the following 3 types of cases. Any case involving the Constitution. So there's a question as to whether something is or is not a violation of the Constitution. That's going to go to the Supreme Court. Anything involving federal law. In other words, this law was passed. Is it constitutional? Is it legitimate? Is it right? And then any treaty that we sign. Does the treaty violate the Constitution? So any cases relating to those 3 issues, the Supreme Court is the final authority. All right? And that's it. Once you have a case that's heard before the Supreme Court, and if you don't get the outcome you desire, that's going to be it. Unless you can write an amendment to the Constitution or get an amendment passed, that's going to be the end of your battle. Now, the Supreme Court's changed over time, the way that society changes and things change in the Supreme Court. But in general, their rulings, that's the end of the road for you as far as cases are concerned. We're going to talk a little bit about how we select the justices. Then we're going to talk about, I'm going to show you some pictures of them and the current court. But ultimately, and you guys, again, this is something we've done in class. We talked a little about how they're put into place. First and foremost, I think, and even before we talk about the appointment part, is that justices are in place for life. And that seems a little strange for us because we feel like, well, the president has term limits. The House of Representatives only 2 years, Senate 6. Why do we do lifetime for the justices? And if you really want to get a good reason or rationale for it, you could read Federalist Paper number 78. That's one of the James Madison's arguments as to why the Supreme Court justice should be for life. But really what it comes down to is that if you make a justice have to get reelected or appointed every few years, that it takes away their ability to adjudicate without pressure. They want those justices to rule on law, and they don't want them to feel pressured to maintain their office, to get back in there, that kind of stuff. So, again, the reality of it is that it's a great job because you're in it for life. Beyond that, when we're talking about Supreme Court justices, what happens is that the president will go through a long list of justices that are potentially ready to serve that position on the court. They've got to have a lot of experience, probably at different levels of federal court systems, things of that nature. And it starts there. Then the president will start working with the Senate, because the Senate is going to need to approve the justice, and in particular, a part of the Senate, and that is the Senate Judiciary Committee. The Senate Judiciary Committee's one of their main responsibilities is to approve justices in any federal court. members or appointees. So that's where it starts. And so this Senate Judiciary Committee is going to work hand in hand with the president to make sure that the possible candidates are viable to both groups. And sometimes that's a problem when you have a Democratic president or a Republican president, and then the Senate is of the other party. And so sometimes you'll have some differences there. Once that Senate Judiciary Committee reviews, they will do a series of hearings. They'll ask the justices questions. They'll, this is televised now. It's something that we cover in the news. Then they will vote as a Senate body on whether or not they want to approve this person. So it goes through that process. If they pass, then they're on the court, and that's it for life. If they don't, then they will start again, and they will look for another justice to fill that seat. I also mentioned on here senatorial courtesy. What happens here is that when there is a federal judge appointment needed, there's 12 federal court districts, closest one to us in LA. If there's a federal court appointment that needs to be made, they have something called senatorial courtesy. And what happens there is that when that president appoints that judge, the senator of the state in which that judge is going to be serving has the right to either approve or sort of disapprove of that particular justice. If that senator approves it and they like the idea, then for the most part that appointment's going to become kind of a rubber stamp. If they don't like it, there may be hearings and it may go a little farther. So the senators are given something called senatorial courtesy. In fact, most of the time the president talks to that senator beforehand and says, hey, are you okay with this guy or this gal in this spot? And again, it's just something where it's not in the Constitution. It's just something we've done out of courtesy. So let's look at the Supreme Court. I'm going to go to a website here that shows you all the justices, because again, these are people you wouldn't normally see, and they're names that you should probably know and you probably don't. We'll start here. This is Chief Justice John Roberts. Now, he's relatively new to the court. President George W. Bush put him into the court in 2005. He's a fairly young judge. He's 50 years old, sorry. And so he's going to be there a while. Again, barring some catastrophe physically, but he's one of the younger justices and happens to be the Chief Justice. The oldest tenured justice at this point, I think I'm correct on that, is Justice Scalia. And Scalia was I believe he was a Reagan appointee, if I recall. Yeah, he was a Reagan appointee. And he's been on the bench for a long time. And again, he's definitely one of the more famous justices just because of his tenure at this point. As we go through. Justice Kennedy, excuse me, another Reagan appointee, has been on the court since the year I graduated from high school in 1988. And, Justice Kennedy has been there quite as while. Sliding down a little bit farther, we get Clarence Thomas. Clarence Thomas created a little bit of a stir when he was going through the process of getting his approval, because they claimed he had committed some sexual harassment to one of his secretaries. It ended up being false, but that happened during his process of getting the Senate confirmation hearings, and so there were some issues there. But he's been on the court since '91. He's a President George H.W. Bush appointee. Justice Ginsburg is a Clinton appointee, and one of the three women on the court now, and it's a new thing for us, obviously, to have that many females on there. Justice Breyer, a Clinton appointee as well, in 1994. And again, just another one of the justices. Sliding down here, Justice Alito was a George W. Bush appointee. He only appointed one justice in his tenure, his 8 years, and that was Justice Alito. And then we have two appointees from Barack Obama, both females. Justice Sotomayor, who just went in 2009, and then Justice Kagan, who just went in here in about the last year, August of 2010. So these are the justices, and there's some faces to go with, as you're hearing some of these names. And again, you probably wouldn't recognize these people. Could probably sit down with you at dinner and you wouldn't know who they were, because they're not in the news media. They're not, they're not in that type of position. Okay. Ideology. This is a really important part about this. First of all, is that the judges have to be competent, and that's really where this is going to start. Have the judges proved through their actions and their experiences to be competent judges, and that really is at the heart of this. They're very, very intelligent people. They know the law, they know the Constitution. Have they proved this? They typically would share some of the beliefs of the president in office, but they also have to meet the ideology of the Senate committee. And, you know, as we've gone farther and farther and got closer to our time periods today, it is, for the most part, we have moderate judges in there. Now, does the court shift back and forth between maybe more conservative and more liberal? Of course it does. But today's justices tend to be a little bit more moderate because of the political makeup of our country right now. We've had divided government. You know, again, one party is president, the other party's in the Senate for a long time. And so that creates some ideological issues, and what it does is it forces us to pick centrist judges. I mentioned on here symbolic representation because, you know, really these justices, what do they really represent? Or is this idea that they have ideologies that match the president or don't match the president, are they really true? Well, I think for the most part that the justices judge the law, and that's really what we want from them. And so as a member of our society, as much as the Supreme Court makes really critical decisions, you know, they tend to back this up with very legitimate ideological statements and things that they do. So anyways, that seems to be fairly normal. Actually, and let me go back a slide here, because here's what I would like you to do. I want you to look up each of the 9 justices. There's only going to be 2 questions on this for this Dropbox, but I want you to go to each of the 9 justices, and I want you to tell me where you believe they were, you know, based on who put them into office, what their ideologies were, and then I want you to tell me what the current viewpoint is of them. Okay, and that's keep in mind that's going to be 18 answers you're going to give me. Now, it doesn't have to be really extensive, but based on who put them into office, were they supposed to be conservative or liberal? And then based on how they've acted as a judge, have they followed up with that? Is that still true? That's what I want to know. Okay, so that'll be your first question for your Dropbox. All right, the jurisdiction. And all courts have jurisdiction. You know, you get a traffic ticket leaving campus here outside of Orange Lutheran, and you're going to get pulled over by the Orange PD. The Orange PD has jurisdiction for the city of Orange over traffic violations. So that's what we mean by a jurisdiction. It's the areas that they cover. In this case, I want to talk about the fact that the Supreme Court has 2 types of jurisdiction, in the sense of any cases that are heard, they can either be originally heard in the Supreme Court. That means that the case is heard for the first time in front of the United States Supreme Court. This is a very rare occurrence. Most of the time, cases are heard at other levels of federal court. But most of the cases that we hear in the Supreme Court are appealed. And they're either appealed through the state court systems, and then ultimately the Supreme Court, or through the federal court systems, and then the Supreme Court. So they work their ways up through those court systems until they reach the Supreme Court. Now, again, of all the cases, you're talking about like 98% are heard on appellate jurisdiction. All the big cases, the ones you've heard of, Miranda versus Arizona, right? The idea that you have to be read your rights when you get arrested. Texas versus Johnson, the case that says that you can burn an American flag. All those are appeals. Those cases were not heard for the first time inside the Supreme Court. They were heard from appeal. However, I just don't want to mention that there are 2 ways that a case could be heard, at least in an original format. One is if a state is a party. In other words, if the state of California is suing the United States, or a person is suing a particular state, or vice versa, those cases could have original jurisdiction. Second is if it includes an ambassador or public minister. For example, one time, you know, there's a very famous Supreme Court case, the United States versus Nixon. That case was originally heard in the Supreme Court. Okay, and so those cases are heard there first. All right, fairly unusual. Most of the cases are heard on appeal. So how do they get there? What happens? Well, the court decides which cases they are going to hear, and on a given year, they're probably they're asked or requested to hear about 4,500 cases. And what they do is that the cases are, the attorneys involved in the cases are working their way up the system and decide that they want to get one more chance to hear the case, and so they go about the process of attempting to get the Supreme Court to agree. Supreme Court has a rule. They say that in order for a case to be heard, at least 4 justices have to agree to want to hear the case. And if 4 of the 9 agree that they want to hear it, then the court will accept the case and hear it. How are cases done? This is not Law and Order. This is not your typical courtroom drama by any stretch of the imagination. For the most part, the lawyers have a very limited amount of time to present arguments. There's no witnesses. There's no cross-examinations. This is a lawyer giving a little bit of a speech to the Supreme Court. Sometimes it's as many as like 3 or 4 minutes. Other times it's maybe 45 minutes to an hour. But it's a very quick, fast thing. The justices sit up front. The attorneys for both sides sit, kind of behind these little barrier kind of things, and it's a very straightforward thing. That's what happens in person. But most of the information that is dealt with or looked at is all the previous information from the other cases that as it moved its way through the court system, and something called legal briefs. And these briefs they're basically papers, an argumentative paper or essay that's written to support one side or the other in the case. And these briefs can come from anybody. If there's some topic that's out there that is being discussed in the court, and a group of people find that it's important for them to hear, they may have an attorney write a brief on behalf of that particular case. But these are legal briefs, and they are presented to the Supreme Court, and they are used quite heavily in adjudicating the cases. The judges decide by vote. They meet, they go through, they decide, and of the 9, obviously you've got to get at least 5 votes to win. And then what happens is the justices write opinions. The majority opinion, in other words, the opinion of the group that won the vote, they write an opinion, and then so does the minority opinion. That way, everyone kind of gets an idea of what some of the issues were in play. And sometimes Supreme Court cases get decided, and those minority opinions can be used later on if there's a case that's similar but slightly different that may have been something that was affected by that minority decision. All of the opinions for every case are public. They're made available to attorneys. If you go to law school, trust me that you will have to memorize many of those decisions and the cases and the opinions around them. So, it's just something that's going to be out there. So that's how courts are decided. The decisions are rendered, and both sides are known, and then that's it. That's the end of the case, and there's nothing really much more to do after that. Okay, so that leads us to our last question, and that is this. I want you to pull and look at, in the last 6 months, you are going to pull out a current case that the Supreme Court is hearing. And you're going to tell me about the case, who the two sides are. Then you're going to tell me how the Supreme Court ruled on the case, and why it ruled that way. Okay, so again, pick a case from the last 6 months that's currently in the Supreme Court. You're going to tell me what the decision was, is it 5-4, 6-3, what have you. And then you're going to tell me why it was ruled in that form. Okay, so you've got those 2 questions, put them into the Dropbox, and we will be all set for our Supreme Court assignment. Thank you.